Welcome back to the Deep Dive. This is where we take really dense source material, things like statutory law, complex science, industry reports, and we basically distill it down so you get the crucial knowledge you need without all the jargon getting in the way.
Exactly, making the complex accessible.
Today, we are doing a really critical deep dive into Texas law. We're focusing specifically on Chapter 20 of the Penal Code. Now, this chapter, it defines a whole hierarchy of offenses about, well, restricting personal liberty. We're talking unlawful restraint, kidnapping, aggravated kidnapping, and then this unique offense, smuggling of persons.
Right, it's quite a range.
So whether you're maybe doing some professional development or perhaps you're in legal studies, or honestly, if you just want clarity on where the law draws these really fine lines between complex crimes, our mission today is to decode that precise statutory language for you.
And that precision is key here.
We're going to clearly distinguish, using only the code itself, that's our source, what separates, say, a minor offense from a serious first-degree felony. And we'll spend real time analyzing the subtle but really profound differences in intent.
Because intent changes everything in this area of law. It really does.
Yeah, absolutely. Now, before we jump right into the legal text itself, look, we put a massive amount of effort into synthesizing this stuff.
We do.
And if you find these deep dives valuable, please just take a quick second right now, hit that subscribe button. It really supports the channel.
It's the best way to help us keep growing, keep tackling these important, sometimes difficult topics.
And also check out our website. We've got supplemental materials, outlines from, well, all our past dives. It's a good resource.
And thank you for that support, really. Now, as you said, it's essential when we're analyzing material this complex to remember our constraints. We're sticking strictly to the text of the Texas Penal Code, Chapter 20.
Just the facts from the statute.
Exactly. The legislature has spent significant time crafting these definitions. And like you mentioned, the whole structure, the stratification, it's built on just a few foundational terms.
Right.
If you don't master those core definitions first, the offenses that follow, they just don't really make sense in context.
Okay, let's unpack this then,
Yeah.
starting with those fundamental building blocks of criminal restraint. Right, so every single offense we're going to talk about today in Chapter 20, it hinges on one of two key terms, either restrain or the more serious concept, abduct.
That's the core distinction.
Let's start with the baseline, restrain. This is defined right there in Section 20.01, subsection 1. And it's defined as restricting a person's movements without their consent, and importantly, in a way that substantially interferes with their liberty.
Yeah, that phrase, substantially interferes with their liberty, that's really crucial.
Why substantially?
Well, it prevents, a simple momentary touch or maybe just redirecting someone briefly from becoming a criminal act. It needs to be more significant than that. And crucially, the statute then specifies two physical ways this restraint can actually happen. You have to either move the person from one place to another.
Okay, physically transport them.
Or alternatively, you can find the person.
So lock them up somewhere.
Right. It's a key legal distinction, isn't it?
Yeah, why is the law so careful about including both moving and confining? It seems like it covers all bases.
It does, because investigators, prosecutors, they need to prove one or the other. If you lock someone in a closet, that's clearly confinement, even if they haven't been moved from their own house.
Right.
But if you force someone into a car and just drive them, say, a block away, that's moving, even if the confinement itself was really brief.
Ah, okay.
The goal is basically to cover all forms of unauthorized restriction. And how that restriction is achieved, well, that helps determine if it's legally without consent.
Okay, so let's talk about that without consent part. The default method, subsection 8, it seems pretty intuitive, using force, intimidation, or deception.
Standard ways to overcome someone's will, yes. Force is obvious. Intimidation uses threats. Deception tricks them.
But then subsection B gets really specific, particularly about vulnerable victims.
Absolutely. Subsection B addresses situations involving children or legally incompetent persons. And in these special cases, the restraint is legally deemed without consent, even if the victim themselves physically goes along with it, and this is the key part, if the parent, guardian, or someone acting in loco parentis, basically in place of the parent, has not acquiesced, has not agreed.
So the victim's passive acceptance, maybe they don't resist. That doesn't matter if the lawful custodian objects.
Exactly. The parent's or guardian's control and consent overrides the child or incompetent person's ability to legally consent in these scenarios.
And the statute then lays out two Quite different scenarios based on the victim's age and also how far they were taken. Let's start with the most vulnerable group first.
Okay, scenario 1 covers any victim who is legally incompetent regardless of age or any child under the age of 14.
Under 14?
Yes. So imagine a 5-year-old child willingly goes with a stranger, maybe just sits on a park bench with them, but the parent didn't agree to that.
Right.
The law automatically views that interaction as restraint without consent, purely because the parent's authority and lack of agreement overrides the child's inability to give meaningful legal consent.
Okay, that makes sense for younger children. Now, the second scenario deals with older minors, those who are 14 or older, but still younger than 17.
Correct. And the conditions here are clearly designed to target actions that go beyond, say, local, temporary runaways or minor teenage conflicts. It requires more serious circumstances.
How so? What are the conditions?
For this older age group, 14 to 16-year-olds, the restraint is only considered without consent just because the parent didn't agree if two things happen together. Both must be true.
Okay, what are they?
First, the minor has to be taken outside the state of Texas.
Across state lines.
And second, they must also be taken outside a 120-mile radius from their residence.
Wow, okay, 120 miles and out of state. That's quite specific. Let's apply that. That geographical constraint, the mileage, seems really crucial.
Oh, it is.
So if a 16-year-old runs away and someone takes them, say, 50 miles across the state line into Oklahoma, that restraint, well, maybe not a good idea.
Probably not advisable, no.
It might not actually meet the criminal standard under this specific subsection if the 16-year-old went along willingly.
That's likely correct, because the act, even though it crossed state lines, happened within that 120-mile buffer zone from their home.
So the legal trigger for voiding consent based only on the lack of parental agreement hasn't been pulled.
Exactly. However, let's change the facts. Same 16-year-old willingly goes, but this time they're taken 150 miles into Oklahoma.
Outside the 120 miles.
Now the legal line is crossed. Under this provision, it immediately becomes restraint without consent, assuming the parent hasn't acquiesced.
So it's a very deliberate line drawn by the legislature.
Seems so. It distinguishes that serious long-distance removal from maybe more common short-range custody disagreements or, some teenage dramas.
Okay, that clarity helps a lot. That covers restraint.
Yeah.
Now let's move to the concept that really escalates the crime. Abduct. Defined right after in 20.012.
Right. An abduction is fundamentally different. It's restraint plus something more. It requires a distinct and, frankly, malicious intent. The intent to prevent the person's liberation.
Prevent liberation, so not just hold them temporarily.
Exactly. It signifies an intention not just to restrict their liberty for a bit, but potentially to hold them indefinitely or make them permanently unreachable or at least make it very hard to find them.
And the statute requires proof of that intent. How is that shown?
Well, the statute says the intent has to be demonstrated by one of two specific methods. The method is the evidence of the intent, essentially.
Okay, what are the two methods?
Method 1. Secreting or holding the person in a place where he is not likely to be found.
Hiding them.
Yeah, basically. Hiding, camouflaging, holding someone in a remote location, an undisclosed basement, anywhere the average person wouldn't stumble upon them.
And method 2?
Method 2 is simpler and more overtly violent, using or threatening to use deadly force. The moment that threat of irreversible harm, deadly force is introduced during the restraint, the law considers the intent to prevent liberation as inherently proven, because the goal becomes immediate, total control through fear of death or serious injury.
Okay, so this is really where the core logic of Chapter 20 starts to take shape. As we analyze this, it seems like abduct is the essential gateway term.
It absolutely is.
Unlawful restraint just needs that basic definition of restraint.
Right.
But kidnapping, as we'll see, specifically requires abduction.
Exactly. And what's fascinating here, if you connect the dots, is how the legislature uses that combination about the mental state, that intent to prevent liberation, and the method used, either secrecy or deadly force, as the kind of legal tripwire.
Tripwire, yeah.
It ensures that only those crimes with a sufficiently malicious, high-risk profile actually transition into the much more serious kidnapping category. If someone restrains another person briefly, maybe in anger, but then immediately lets them go.
They might be looking at unlawful restraint?
Possibly, yes. A misdemeanor, maybe a state jail felony, depending on the circumstances. But if they drive them across the country, lock them in a hidden room, and threaten them with a weapon...
They've clearly crossed over into abduction territory.
No question, that's kidnapping or worse.
Got it. And just quickly, to round out these foundational terms from 20.01, relative is defined pretty broadly, right?
Yes, it covers parents, step-parents, siblings, ancestors like grandparents, uncles, aunts, and it specifically includes those by adoption or by marriage. So step-relatives count, in-laws in some cases.
Okay, and individual just means a human being who has been born and is alive.
Standard legal definition there. Those are the potential victims of these crimes.
Okay, now we can build on those definitions and look at the baseline offense. Unlawful restraint, section 20.02. The standard in subsection A seems pretty straightforward.
It is. It says you commit the offense if you intentionally or knowingly commit the act of restraining another person, using that definition we just discussed.
So if someone uses the basic definition, moving or confining without consent,
And does it intentionally or knowingly, they fall into this category. The base classification, the starting point, is a Class A misdemeanor.
which is punishable by up to a year in county jail, maybe a fine.
Correct. But the law immediately recognizes that certain factors can dramatically increase the severity, even for simple restraint.
Right, these penalty escalations. Let's explore those, starting with the specific protection for minors.
This is a big jump. The first major escalation happens if the person being restrained is a child younger than 17 years of age.
Younger than 17.
That simple fact, the victim's age, immediately elevates the offense from a misdemeanor straight to a state-jailed felony.
Okay, so potentially 6 months to 2 years in state jail.
Exactly. The legislative intent seems crystal clear. Minors are highly vulnerable. Any unlawful restraint of a child, even if it doesn't meet the higher standard for abduction, is treated as a serious crime right off the bat.
Okay, then we have 3 distinct scenarios that push the crime even higher, up to a third-degree felony.
Right. And a third-degree felony carries a potential sentence of 2 to 10 years in prison, so a significant increase.
What's the first scenario?
The first third-degree enhancer focuses on negligence related to the victim's safety. It applies if the actor recklessly exposes the victim to a substantial risk of serious bodily injury.
Note the word recklessly.
Yes, that's key. The state doesn't have to prove the actor intended to hurt the victim. They only need to show that the actor's actions while restraining the victim, like, say, chaining them up in a dangerously unstable shed or leaving them locked in a car in extreme Texas heat, created that substantial risk, and the actor was aware of the risk but disregarded it.
Okay, that makes sense. The second and third enhancers involve the status of the people involved, either the victim or the actor.
Indeed. The second one applies if the actor restrains someone they know as a public servant, could be a government employee, various officials, while that person is lawfully carrying out their duties, or if they do it in retaliation for those duties.
Protecting government function.
Right. And the third covers offenses within the system itself. If the actor is already in custody, meaning detained, incarcerated, or maybe committed to a civil commitment facility, and then they restrain any other person inside that facility.
A security breach inside a secure environment.
Exactly. It's viewed as a significant disruption and danger within that controlled setting.
And the escalation for unlawful restraint?
Yeah.
It tops out at a second-degree felony.
Yes. And this highest level specifically targets attacks on the highest levels of judicial and law enforcement authority.
How so?
If the public servant who is restrained is known by the actor to be a peace officer or a judge, the offense jumps all the way to a second-degree felony.
2 to 20 years potential sentence.
Right. It shows the state's strong commitment to penalizing attacks against those core functions of justice and law enforcement with really maximum severity, at least within this particular statute.
Okay. Now, let's switch gears a bit and talk about the legal outs, the affirmative defenses provided under 20.02. These seem crucial because they recognize that not all restraints, particularly involving kids, are purely criminal in nature.
They are absolutely crucial, especially in family law contexts. The first offense, laid out in subsection B, is really essential in, say, custodial disputes or complex family situations.
What are the conditions?
It applies only if 3 things are true. 1, the person restrained is a child under 14 years old. 2, the actor is a relative of that child, using that broad definition we discussed. And 3, the actor's sole intent was to assume lawful control of the child.
Sole intent. That seems important.
Very. So imagine a parent who has joint custody, and they genuinely believe the other parent is endangering the child, so they take the child back. They might be able to raise this defense against an unlawful restraint charge.
Okay. But how does the statute prevent this from just becoming a loophole for someone acting maliciously?
Well, it's tightly controlled in a couple of ways. First, as you noted, the actor has to prove their sole intent was about lawful control. Any other proven intent, like trying to get ransom or intending to harm the child or even just spite negates the defense.
Right.
Second, remember, this defense only applies to unlawful restraint. By definition, unlawful restraint lacks that higher level intent or the use of deadly force that defines abduction, so it can't be used to excuse kidnapping.
And the burden of proof is on the defendant.
Yes, it's an affirmative defense. The defendant has to prove these elements by a preponderance of the evidence, meaning more likely than not.
Okay. There's also a second, very specific defense for slightly older children, those aged 14 to 17, found in subsection E.
Yeah, this one's a bit more complex. It looks like a kind of carve-out designed to maybe protect older teenagers involved in peer-level conflicts or situations that don't involve coercion.
What does it require?
It requires 3 cumulative conditions again. All must be met. 1, the child victim must be 14 or older, but younger than 17. 2, the actor cannot use force, intimidation, or deception to restrain them.
So no coercion.
Right. And third, the actor can be not more than 3 years older than the victim.
Ah, the age gap matters.
Critically. So if a 19-year-old restrains a 16-year-old, even without using force, they can't use this defense because the age gap is 3 years, which isn't more than 3 years. Wait, let me rephrase. The actor cannot be more than 3 years older. So a 19-year-old restraining a 16-year-old is exactly 3 years older, so they could potentially use it. But if a 20-year-old restrains a 16-year-old, that's 4 years older, so the defense is unavailable.
Okay, so it's really aimed at near-peer situations. A 17-year-old restraining a 16-year-old without force, they could potentially use it?
Correct. It seems aimed at those peer-to-peer restraints that lack the elements of adult coercion or potentially predatory behavior.
And we should definitely reiterate that important carve-out in subsection D. It explicitly states, it is no offense for law enforcement or other authorized people to detain or move someone lawfully, like during an arrest.
Absolutely essential clarification. That protects the necessary professional functions of police and other officials acting under legal authority.
All right, now we're moving firmly into the high felony territory. Let's analyze kidnapping itself, section 20.03. The transition here seems simple on the surface, but it's profound. The required action shifts from restraint to abduction.
That's the fundamental shift. Simple kidnapping under 20.03 is committed by intentionally or knowingly abducting another person.
Using that definition, we covered restraining with intent to prevent liberation, either by hiding them or using threatening deadly force.
Exactly. And because abduction inherently involves that more malicious intent and method, we immediately jump past the lower misdemeanor or state jail felony levels we saw with unlawful restraint.
The base classification for just simple kidnapping is a felony of the 3rd degree.
Correct. 2 to 10 years in prison potential.
Now, what about that affirmative defense for relatives we just discussed for unlawful restraint? Does a similar defense exist here for kidnapping?
It does exist in subsection B, but it's dramatically narrowed precisely because we're now dealing with abduction, not just restraint.
How is it narrowed?
The defense, again, that the actor was a relative and their sole intent was to assume lawful control is immediately defeated if the abduction was coupled with the intent to use or threaten to use deadly force.
Ah, that's the critical line then.
Absolutely critical.
So if deadly force, or even the threat of it, is used while taking the child, even if it's a parent who truly believes they're acting in the child's best interest in a custody fight, they can no longer claim this specific affirmative defense against a kidnapping charge.
Precisely. The law essentially says that introducing deadly force automatically moves the behavior out of the realm of a potential family dispute defense and squarely into the realm of severe criminal malice, regardless of the familial relationship involved in that specific context.
Okay, now, here's where it gets really interesting. Let's talk about aggravated kidnapping, section 20.04. This seems to be the offense where abduction is combined with some truly malicious purpose or action.
That's exactly right. Aggravated kidnapping occurs when the actor commits the underlying act of abduction, and in addition to that, they have the specific intent to accomplish one of 6 highly nefarious goals. These goals demonstrate a profound danger to the victim, or sometimes to society at large.
Let's definitely dedicate some time to breaking down these 6 intents listed in 20.04a, because they really illustrate the scope of harm this law is trying to prevent.
Okay, let's go through them. Intent number 1. Holding the victim for ransom or reward.
The classic kidnapping for money scenario.
Yes. Intent number 2. Using the victim as a shield or hostage, basically turning the person into a tool for the actor's own protection or as a bargaining chip.
Okay. Intent number 3 seems to link the abduction directly to other criminal acts.
It does. Intending to facilitate the commission of a felony or flight after committing a felony. So if you abduct someone to force them to help you commit, say, a burglary.
Or maybe you grab a bystander to slow down the police while you're escaping a bank robbery.
Exactly. Both of those situations would fall under this intent, making the abduction aggravated.
Intent number 4 focuses squarely on direct harm to the victim themselves.
Yes, this is the intent to inflict bodily injury on the victim or violate or abuse the victim sexually. This covers both non-fatal physical assaults intended during the abduction, as well as any form of sexual assault or abuse.
And intent 5 seems more psychological.
It is, and potentially far-reaching. Intending to terrorize the victim or a third person. So abducting someone's child specifically to inflict terror on the parent, for example, clearly falls under this category. The terror itself is the goal. And finally, intent number 6 targets societal function, intending to interfere with the performance of any governmental or political function.
Like abducting a key witness before a trial.
Or a judge, or a political figure, or someone critical to running an election, yes. Any abduction aimed at disrupting government or politics fits here. So you see, these 6 intents show that the crime has moved far beyond just restricting movement. It's about using the abduction and the victim as a means to a much larger, more dangerous criminal end.
That's very clear. Now, beyond those 6 specific intents, subsection B provides an alternative way to reach aggravated kidnapping. Right? It relies only on the weapon used.
That's a really key structural element of this law.
Yeah.
Even if the state prosecutors cannot prove one of those 6 underlying intents we just listed.
Maybe the motive is unclear.
Right. If the actor commits abduction and during the commission of that offense they use or exhibit a deadly weapon, the offense is automatically elevated to aggravated kidnapping.
Just the presence and use or display of the weapon is enough.
Yes. The sheer presence and active use or exhibition of a deadly weapon during the abduction itself is deemed serious enough by the legislature to trigger the highest severity level, regardless of proving one of those other specific intent.
And the standard classification for aggravated kidnapping is a felony of the first degree.
The most severe category, yes. Punishable by 5 to 99 years or life in prison.
Okay, but let's spend some significant time here on the mitigation opportunity, what the outline calls the voluntary release clause in 20.04 P-Day. This isn't just a procedural detail, is it? It feels like a statement of public policy.
Oh, it absolutely is. It's a profound public policy choice embedded right in the statute. The voluntary release clause allows the defendant during the punishment phase of the trial after they've already been found guilty of aggravated kidnapping.
Okay, after conviction.
Yes. They can raise the issue that they voluntarily released the victim alive and in a safe place.
Voluntarily, alive, and safe. Key elements.
Crucial. If the defendant manages to prove this by a preponderance of the evidence, remember, that's the lower, more likely than not standard, not beyond a reasonable doubt.
Right.
Then the offense classification is mitigated. It's reduced down from a first-degree felony to a felony of the second degree.
So the sentencing range drops significantly, from potential life down to a maximum of 20 years.
Exactly. It's a huge potential difference.
What's the thinking behind that? Why would the law allow such a significant potential reduction for someone convicted of such a serious crime just for letting the victim go?
Because the state is clearly trying to incentivize the single most important outcome in these terrible situations, the victim's safe return.
Prioritizing the victim's life.
Absolutely. By offering this potential significant mitigation in sentencing, the legislature is actively encouraging the defendant, even one facing a very dire conviction, to choose to return the victim safely rather than perhaps harming them further or concealing them permanently out of fear of facing that mandatory first-degree sentence range.
It prioritizes the victim's life and well-being over simply maximizing punishment severity in every single instance.
That seems to be the clear policy goal. And note, the safe place requirement is also vital. The defendant can't just, push the victim out of a moving car on a highway and claim they released them. It has to be somewhere the victim isn't immediately in further danger.
Okay, so we've covered the crimes that target an individual victim's liberty restraint, kidnapping. Now we pivot to a different kind of offense in Chapter 20, one that seems focused more on organized movement and perhaps state security. Smuggling of persons. Section 20.05.
Yes, this offense is structurally quite different. It focuses on knowingly engaging in specific actions related to the transportation, concealment, or harboring of individuals, often in violation of immigration laws or to avoid law enforcement.
The section defines 3 distinct types of conduct that constitute smuggling. Let's break those down. What's the first type of action?
Okay, Action 1 deals with the physical transportation itself. It involves transporting or concealing an individual using some kind of conveyance, a vehicle, a boat, an aircraft, etc., with one of two specific intents.
Two intents again.
Yes. Subsection A is the intent to conceal the individual from a peace officer or a special investigator. Subsection B is the intent to flee from a person the actor knows is a peace officer or special investigator trying to lawfully arrest or detain them.
So either hiding people during transport or running from the cops while transporting people.
Essentially, yes. The key is using the vehicle specifically to avoid detection or to evade capture related to the people being transported.
Okay. Action 2 seems focused less on the initial transport and more on enabling someone to stay somewhere illegally.
That's right. Action 2 is encouraging or inducing a person to enter or remain in this country in violation of federal law by doing things like concealing, harboring, or shielding them from detection.
So this targets the infrastructure, providing safe houses, maybe fake jobs.
It seems aimed at that longer-term support structure required to maintain an unlawful presence, yes. Providing shelter or work arrangements specifically designed to protect them from being found by authorities.
And Action 3 is very specific, kind of blending smuggling with trespassing. Agricultural land trespass.
It is very specific. This action makes it illegal to assist, guide, or direct two or more individuals to enter or remain on agricultural land without the effective consent of the owner.
Why include this specific act guiding people across farmland in the smuggling statute?
Well, think about the context, especially in border regions. It seems clearly aimed at those individuals who intentionally guide groups of people across large, often remote, private ranches or farms.
To avoid roads and checkpoints.
Precisely. To bypass official ports of entry, checkpoints, or establish transportation routes, thereby shielding the group from detection by law enforcement. It treats this specific form of trespass facilitation as part of the broader smuggling enterprise.
Okay. Now, the base penalty for smuggling of persons, it starts high, doesn't it?
It does. It immediately reflects the often organized, serious nature of this crime. The base offense is a felony of the third degree.
2 to 10 years, like simple kidnapping?
Yes, but with a very significant addition. It carries a mandatory minimum term of imprisonment of 10 years.
Wow. A 10-year floor right from the start.
Yes. That 10-year mandatory minimum shows the legislature views these acts, even at their baseline, as extremely serious crimes requiring a substantial deterrent. It applies even if none of the later aggravating factors are present.
That's a strong statement. Now, given the organized nature, it makes sense that the statute includes an incentive for defendants to cooperate. Let's talk about the significant cooperation clause in subsection B1.
This is a really powerful tool for prosecutors aimed directly at dismantling these smuggling networks. The clause allows for a significant reduction in that mandatory minimum sentence if the actor provides substantial cooperation to the state or law enforcement.
What counts as substantial cooperation?
Well, it could be providing credible evidence against others, identifying leaders or co-conspirators, maybe locating victims or other smuggled individuals, or even testifying in court.
And if they cooperate significantly?
If the attorney representing the state certifies this cooperation in writing to the court, the mandatory minimum term of imprisonment can be reduced from 10 years down to 5 years.
Having the mandatory minimum.
Yes. It's a mechanism built entirely to break open criminal organizations from the inside, offering a serious potential benefit in exchange for actionable intelligence that helps take down the larger operation.
Okay. Now let's detail the factors that escalate the offense beyond the base third-degree felony, but still keep that 10-year minimum. These factors push it up to a second-degree felony.
Right. Several factors trigger this jump to a second-degree felony classification, while importantly maintaining that 10-year minimum sentence. These include if the smuggling conduct created a substantial likelihood of serious bodily injury or death to the people being smuggled.
Dangerous conditions, overloaded vehicles.
Exactly. Also, if any smuggled individual is a child younger than 18 years of age.
Protecting minors again?
Consistently. Also, if the crime was committed with the intent to obtain a pecuniary benefit, basically, doing it for money, establishing a profit motive.
Makes sense for organized crime.
If the actor knowingly possessed a firearm during the offense. And finally, if the actor was actively fleeing from a peace officer or special investigator during the transport, as described back in subsection A, 1B.
So these factors generally layer on increased risk, victim vulnerability, profit motive, or direct confrontation with law enforcement.
That's a good summary, yes. Any of those bumps it to a second-degree felony, still with the 10-year floor.
And the highest level of first-degree felony is reserved for the absolute worst outcomes.
Yes. If, as a direct result of the smuggling offense, the smuggled individual became a victim of sexual assault or aggravated sexual assault, or if the individual suffered serious bodily injury or death.
Catastrophic harm during the smuggling.
Right. If those tragic outcomes occur, the charge jumps to a first-degree felony, still with that mandatory minimum 10-year sentence, but the maximum punishment is now life in prison. The law makes it clear that the penalty is most severe when the operation directly results in this kind of extreme harm.
Okay. Finally, for this section, just like we saw with kidnapping, there are defenses based on family relationship, the affinity consanguinity defenses. But the distinction between the second and third degree of relationship seems quite nuanced and critical here.
It is, and it's a perfect example of how precise legal definitions matter. Let's quickly define the terms again. Consanguinity is blood relationship, parent, child, sibling, grandparent, aunt, uncle, cousin, etc.
Got it.
Affinity is relationship by marriage, your spouse's parent, mother-in-law, your child's spouse, son-in-law, etc. And the degree is calculated based on how many steps removed you are.
Okay, so how does the degree affect the defense for smuggling?
If the actor is related to the person they smuggled within the second degree of consanguinity or affinity, think of very close relatives. Parent, child, sibling, grandparent, grandchild, or your spouse's parent, child, parent, spouse.
Okay, immediate family, basically.
Pretty much. If they can prove that close relationship, they have an absolute affirmative defense under subsection C. It means they should be acquitted unless... Big exception. Unless the offense itself involved that substantial likelihood of serious injury or death, or if it actually resulted in sexual assault or death. You can't endanger your close relatives during smuggling and then claim the family defense.
So, smuggling your spouse or your child is likely defensible, provided you didn't put them in grave danger. What about slightly more distant relatives, the third degree?
Right. The third degree includes relationships like great-grandparents, great-grandchildren, aunts, uncles, nieces, nephews, and their spouses. For these relatives, the law is different. It does not grant an absolute affirmative defense.
So no automatic acquittal?
No. Instead, subsection B2 allows the actor to raise this third-degree relationship only at the punishment stage, after conviction. If they prove the relationship, the judge may reduce the punishment down to a third-degree felony level with a 5-year minimum sentence.
A potential reduction, but not guaranteed, and only after being found guilty.
Exactly. And crucially, this potential punishment reduction for third-degree relatives is not available if the original crime involved aggravating factors like using a firearm, doing it for money, pecuniary benefit, or creating that substantial risk of injury.
So the law draws a clear line. It protects immediate family transport quite strongly, if safe, but offers only limited mitigation for more distant relatives, especially if the smuggling looks more professional or dangerous.
That appears to be the legislative balance, yes.
Okay, the law clearly recognizes that smuggling often isn't just a one-time event. That brings us to Section 20.06, continuous smuggling of persons, which seems designed to target the habitual, organized nature of these operations.
Precisely. Continuous smuggling defines a pattern crime. You commit this offense if you engage 2 or more times in conduct that constitutes smuggling of persons under 20.05.
So 2 or more instances of transporting, harboring, or guiding.
Yes, and those 2 or more instances must occur pursuant to the same scheme or course of conduct over a period that is 10 or more days in duration.
10 days or more. So it's explicitly aimed at ongoing, professional, repetitive operations, not just isolated incidents.
That's the clear target.
What's really fascinating here, looking at the notes, is this specific instruction given to the jury regarding the evidence needed for conviction.
Yes, that jury instruction really underscores the focus on the organization rather than just individual acts. The law states the jury does not need to agree unanimously on the specific date of each of the 2 or more smuggling acts.
They don't have to pinpoint exact dates.
No. Nor do they need to agree on the precise conduct involved in each instance, like whether it was transport on Tuesday versus harboring on Friday.
So what do they need to agree on?
They only need to agree unanimously that the defendant, beyond a reasonable doubt, engaged in the prohibited smuggling conduct 2 or more times over that specified 10-day or longer period as part of the same scheme.
That flexibility must make it easier to prosecute the organizers.
It certainly helps ensure that organized, repeat offenders can be convicted based on the pattern of behavior without the prosecution getting bogged down trying to prove the specifics of every single illegal transport or action, which can be hard with clandestine operations.
Okay. And the penalties for continuous smuggling, they start severely, right?
Right.
Reflecting this enterprise nature.
They do. The base offense for continuous smuggling is immediately a felony of the second degree.
Skipping third degree entirely.
Yes. And it also carries that mandatory minimum term of imprisonment of 10 years.
Same floor as regular smuggling, but starting at a higher felony level.
Correct. And this escalates rapidly to a first-degree felony still with the 10-year minimum if the underlying continuous conduct created that substantial likelihood of serious bodily injury or death. Or if any individual smuggled during the continuous operation was a child under 18.
Okay. And then there's the most enhanced penalty in the entire chapter, it seems, reserved for the absolute worst outcomes within an organized continuous operation.
That appears to be subsection G, yes. The offense becomes a first-degree felony, but the punishment range is drastically increased. Imprisonment for life, or for any term of not more than 99 years, but not less than 25 years.
A 25-year minimum sentence.
A 25-year minimum. That incredibly severe penalty is triggered if, as a direct result of the continuous smuggling operation, any smuggled individual suffered serious bodily injury, death, or was sexually assaulted.
So the law attaches absolute gravity to organized smuggling that directly results in severe harm or death.
Unquestionably, a 25-year minimum sends a very strong message.
Okay. Finally, let's examine the infrastructure that enables these crimes. The operation of a stash house, section 20.07. This seems aimed at people who facilitate the crime without necessarily being the ones driving the vans or guiding people across fields.
Exactly. It targets the crucial logistical support, the supply chain, if you will. An offense is committed under this section if a person knowingly uses, permits the use of, or rents property to another person.
And property is defined broadly.
Very broadly. It includes real estate houses, apartments, buildings, but also vehicles, trailers, tents, or really any structure.
And they use, permit, or rent this property for what purpose?
To commit or facilitate the commission of several specific offenses, most notably for our discussion, smuggling of persons, 20.05, or continuous smuggling of persons, 20.06. It also includes certain trafficking offenses, but the link to smuggling is key here.
What does that term facilitate really mean in this context, say, for a landlord renting out a house?
Facilitate essentially means making the commission of the crime easier or possible. So if you rent your house to a known smuggling group and you know they're using it as a temporary holding spot for smuggled individuals before the next leg of the journey.
Even if you never meet the people being smuggled.
Right. Even if you never physically interact with the individuals yourself, by knowingly providing that essential location, you are facilitating the underlying smuggling or continuous smuggling crime. This statute reflects a clear legislative effort to hold accountable every level of participation in these networks.
And the classification for operating a stash house.
The base offense is a third-degree felony, and again, it comes with a mandatory minimum sentence, this time of 5 years.
A 5-year floor for providing the location.
Yes. And it gets elevated to a second-degree felony still with that minimum 5-year term under 2 conditions. If the property was used to facilitate continuous smuggling, the more serious pattern offense, or if, as a direct result of the stash house operation itself, an individual suffers serious bodily injury, death, or sexual assault.
So those who provide the secure locations enabling organized crime are held significantly liable, especially when things go terribly wrong as a result of that operation.
That's the clear intent, yes. Hashtag tag tag outro.
Wow. Okay, this deep dive into Chapter 20 has been incredibly intensive. We've really picked apart the precise differences that can separate a misdemeanor from potentially decades or even life in prison. So, pulling it all together, what does this all mean? How would you synthesize this legal architecture for us?
Well, I think the summary is that the entire structure is built on, let's say, 3 pillars of offense, and each pillar is primarily defined by escalating degrees of intent and specific actions.
Okay, Pillar 1.
Pillar 1 is just restraint, the basic unauthorized restriction of liberty using moving or confining. That leads you to the offense of unlawful restraint, which starts as a misdemeanor, but can escalate based on victim status or risk.
Pillar 2 is the big jump.
Pillar 2 is the critical jump to abduction. This requires restraint, plus that specific intent to prevent liberation, proven either by secrecy or the use or threat of deadly force. That is the absolute demarcation line for entering the territory of kidnapping and aggravated kidnapping.
Yeah, Pillar 3.
Pillar 3 is the specialized domain of smuggling. This targets organized crime, large-scale illicit transport and harboring, and the infrastructure supporting it. It's characterized by those high mandatory minimum sentences, reflecting the focus on deterring criminal enterprises.
So for you, the listener, The most crucial takeaway to retain from all this detail is probably that distinction between simple restraint and abduction.
Absolutely. That second layer of intent, the intent to prevent liberation via secreting or deadly force, that is the legal watershed moment. Figuring out which side of that line an act falls on is often the central question in cases under this chapter, determining whether you're dealing with unlawful restraint or the much more serious charge of kidnapping.
Got it. That's the key distinction.
Now, as we wrap up, here's a final provocative thought for you to consider, something building directly on the specificity we saw in the code today.
Okay.
Given that statutory necessity right at the beginning in 20.01 of distinguishing between moving a victim and confining a victim to prove restrain, how might that distinction influence the actual investigative strategies used on the ground?
How so?
Specifically, think about what types of evidence, CCTV footage, GPS data from phones or vehicles, cell tower pings, maybe witness accounts of seeing someone moved versus locked in a room. What evidence might be prioritized by special investigators trying to definitively prove movement versus proving static confinement in these complex cases? How does the precise legal language potentially shape the forensic or technological focus of an investigation?
That is a fascinating question. Really connects the legal definitions back to the practicalities of fieldwork and technology. Something to mull over.
Indeed.
Well, thank you for joining us for this really detailed deep dive into Chapter 20 of the Texas Penal Code. We sincerely hope this exploration gave you the clarity and the insight you were looking for.
Hope it was helpful.
We'll see you next time on the Deep Dive.